matter of V.A. into brackets by Her Litigation Friend of the official solicitor.
Yes, Mr. Oliver.
Good morning, my lords, my lady. Introductions, if I may.
Yes, I've got one thing to say, but do the introductions first.
I appear on behalf of the Appellant Newcastle City Council. My then friend Mr. Kareem Casey appears on behalf of A, instructed by the official solicitor. We then have an adequate sufficiency, but
I think you're going to have to speak up a bit. A, because I'm getting old, but also because there's a bit of competition from outside.
Yes, certainly. We have, I was going to say, an adequate sufficiency. I'm sure one can't have a surfeit of Mr. O'Brien's. Mr. Michael O'Brien for the respondent B, and Mr. Joseph O'Brien for the NHS Trust, both King's Counsel. Those are the introductions. Our solicitors sit behind us and a representative from the Office of the Official Solicitor.
Yes, thank you very much. I was really just going to make 2 points. Firstly, this case is being live streamed, so the usual, more than the usual care perhaps in not mentioning matters which are not meant to be mentioned. And I will say now, for the purpose of anyone listening on live stream, that there is an order prohibiting the identification of A, herself, the person who this case is about, or her family members, the care home in which she resides, the trust, which is a party, and the treating clinician referred to as Dr. X. It may well be a contempt of court for any of those matters to be publicised. The one matter which the judge has allowed to be public knowledge is that A resides in the north of England. That's as far as we can go. So anyone listening, everyone in court knows that, but anyone listening on live stream must be aware of that. Thank you very much for providing a timetable. That seems sensible. One thing that may affect it is that the court has taken the strong provisional view, unless anyone wishes to persuade it otherwise, that this is not the case for us to give general guidance about covert medication. It's been helpful to have the submissions that we have, but we want to focus really on the circumstances of this case. So to the extent that some of the time for which you've budgeted is going to be taken up on that, you can use it on other things, or perhaps better still, use rather less of it, because it will otherwise be a long day. Lastly, we always say this, but it is particularly true true and important in this case, we have read all the material with considerable care, and you can take it. Of course, there'll be facts you want to emphasise or draw our attention to. We don't need a general introduction to the history or the background. We're very well aware of it.
I'm grateful. With that in mind, may I thank all of you very much for sitting a long day. It's much appreciated. My lords, my lady, this is a detailed judgment from an experienced judge, and this is an appeal against the exercise of a wide discretion. The appellant has those matters well in mind, and it is with regret that we say on appeal that on this particular occasion the judge got it wrong. The second thing I'd like to say at the outset is that it will be necessary and unavoidable for me to say some hard things, I fear, about B. I do that also with regret, and on the understanding that it is likely that whatever the outcome of the appeal, there will need to be an ongoing relationship between the appellant and B, and so I will limit what I have to say as much as I can, but it's a central plank of the appeal, that the weight given to the judge's finding that B is a source of significant harm and a future risk of harm to A, it is something that can't be got around and shouldn't be minimised. The local authority does not say that the judge's decision that A should return permanently to the home and care of her mother would have been wrong in all circumstances. And it could be that there may come a time when that would be the right decision. But the local authority does say that he was wrong to make that decision before exhausting other avenues, that it was a decision that did not require to be made now, and that in making his decision, which was not one that any party was asking him to make, he should have canvassed what he had in mind, with particularly the local authority and the NHS Trust being the state actors whom he was charging with providing protective measures to A. In the difficult circumstances that task would have to be conducted against, namely the permanent and final return of A to her mother's care and the house controlled by her mother. Over the years, the local authority has found itself not able to protect A from the harm that flows from what the judge called her unhealthy relationship with her mother. And that was therefore a disposal that needed to be discussed before a final decision was made. The local authority also says that the judge's decision that A should be told and that B should be involved in telling her that she has been covertly medicated whilst at placement A is problematic for a number of reasons. And there are three in summary. The first is that making B a key messenger, and one can understand the reasons why the judge felt that as the person whom A most trusts, her mother would be the person who had the most traction in getting A to change her mind. But in making that decision, the judge has thereby promoted B as a figure in A's mind whom A is right to trust. But the local authority looks at this judgment and reads over and again the judge's findings that B is somebody who has harmed her daughter, not only throughout her childhood, but into the early years of her adulthood, and that she poses a risk of harm in the future. It seems, although the local authority does not find this clear from his judgment, that the judge's intention is that when B communicates or is part of those, the plan to communicate to A, the fact that A has been covertly medicated, A will not be told the truth about the judge's findings about the harm that B has done to A. The fact that her mother is a source of harm for her will, it seems, need to be concealed from A. That must flow logically from the judge's decisions. For if it were otherwise, A would be at least at risk, if not likely, to lose trust in her mother. Conversely, if A is not to be told the truth about her mother as a source of harm, and the judge is finding that for A, the relationship that she has with her mother is an unhealthy one, then such restoration of autonomy as the judge felt his decision would provide to A is, the local authority suggests, partial, artificial, and based on a further concealment of the truth, or to put it another way, the perpetuation of a different deception. For the local authority, charged with providing measures that mitigate the harm that A will be exposed to if she returns to the care of her mother who has harmed her in the past, this is what it finds a trust paradox. The judge's best interest decisions and his order require that A's trust in B, the person who is a source of harm, is perpetuated, endorsed by the court, and relied upon by the court. And for the local authority, this is a context in which it feels that it is simply going to be unable to provide any protection from harm. In that connection, I wonder if I can briefly take you to two of the subparagraphs of the judge's paragraph 73. These are on page core 110. In particular, little 10 and little 12. At 10, the judge says that covert medication will be unsustainable in the medium or long term at home, and it ought to be stopped on a return home. And then he says, and this must apply wherever covert medication is stopped, stopping medication is likely to raise questions from A, which might lead her to learn that she's being covertly medicated in placement A, and to lose any remaining trust that she has had in healthcare professionals. Pausing there, he's clearly identified the risk of loss of trust in healthcare professionals, and 2 points flow from that. The first is that the implementation of this order now will make it very difficult for A to have trust in healthcare professionals in the future. The judge seems to think that if the telling to A of the truth about covert medication happens in a planned and managed way, somehow perhaps that trust in health professionals could be retained. He doesn't explain how, but perhaps the only way in which it could be maintained is if there is a full explanation that it is not the fault of healthcare professionals or any other professionals that covert medication had to be resorted to. The sole reason why A had to be removed from her mother's care and to be accommodated at placement A so that she could be provided with medication and go through puberty was because her mother would, to use the word of Her Honour Judge Moyer, subvert any plan or attempt for her to be provided with that medication while she remained in her mother's care and at her mother's home. That's the first point. But the second point is that the flip side of this coin is that if there is a risk or a likelihood of loss of trust in those who have covertly medicated her, and if A understands that B is the reason why that had to happen, then, as I said already, there is the risk of the loss of trust in B, which is not grappled with and seems to be a step that the judge is aiming to avoid. And we see that at 12, where the judge says if covert medication is to stop, as he goes on to find that it must, it would be better for A's welfare and consistent with supporting her to make autonomous decisions about treatment in the future to inform her of the facts. And he ends this paragraph by saying that for the messaging to have any chance of being effective, B ought to be involved in delivering it, which begs the question of what B is going to say in circumstances where, in other parts of the judgment, the judge finds that B has not changed and does not think that she has done anything wrong. So I think the only logical interpretation of the judgment, though as I say we don't find it clear, is that A is not to be told that her mother is the reason why she's had to be covertly medicated, and not to be told that her mother was going to stand in the way and undermine medication if any attempt was made to deliver it to her at home. And that is why the deception had to be practiced. My lords and my lady, there is a way in which this judgment might have been workable and could have given effect to A's rights. And that way would have been if B had showed perhaps even a small sign of having changed her attitude, seen the light, and adopted a more A-centred position for the future. The local authority looked with care at the skeleton argument, filed no doubt on her instructions and certainly on her behalf in this court. And one sees not one whisper of any changed position. What one does see is more than one paragraph, beginning with the phrase, B's position is. And what she does is repeat the position that she put forward to Mr. Justice Poole, where he found against her. It is unclear that she accepts the criticisms that he makes of her in circumstances where she puts forward the same position. So if the local authority, with regret, finds no comfort in anything that B has had to say since the decision was made, in circumstances where the judge finds that she does not think that she has done anything wrong, and he saw nothing to indicate that she had changed. We see that at a paragraph that you might be taken to more than once, but it's paragraph 70 on page 108. A's return home to the care of her mother will expose A to a substantial risk of harm flowing from the nature of the relationship. Previously, the enmeshed relationship has resulted in a raft of harms, not just a single type of harm. A being deprived of medical attention and treatment that she required, reasonable medical advice being rejected, significant social isolation. Under the care of her mother, A was underdeveloped physically and mentally, and ill-prepared for independent or even semi-independent living. There is nothing in the evidence I have seen or heard, and of course you know that Mr. Justice Poole heard about a day's worth of evidence from B, to lead me to believe that there will be a marked difference in B's approach to her relationship with A were A to return home. And importantly, B may have learned to say some things that she knows she ought to say to portray a more positive future for A at home, but I have no sense that she has any real desire to change. She gave no impression that she thinks she has ever done anything wrong. And in those circumstances, the local authority asks how practically it has any hope of providing A with protection from the harm that flows to her from this enmeshed relationship to which the judge is returning her on a permanent and final basis. Could I ask you to look at the order, which we have at page 75? And in particular, paragraph 2 on page 76. (2C) was carefully drafted because this is an unusual order
Sorry, did you say B or C?
C.
C. You didn't want us to refer to B at all.
The B is B. I'm. B
It
is
doesn't
there as
matter,
a
right? Just I may have misheard. And
No, B is there as a matter of fact. So the
Yes,
judge there has ordered, or certainly declared,
Yeah.
that B is to be involved in telling A that she's being covertly provided with hormone replacement therapy, and it's C that the return to home, to B's home, and it's important to emphasise this because this is B's property. She controls who comes in, who goes out, and where they can go within the home, and to B's sole care will be in accordance with a return to B with community support plan. And it is important that the order recorded the purpose of that plan. It is aimed at providing A with protective measures to mitigate the risks to A that arise from her relationship with her mother. So A seeks to minimise that by saying, well, the protective measures are the local authority is making too much of those, and they were never intended to be of particular significance, and they would be the usual sort of support that one might expect a local authority to provide to an adult to whom it had duties under the Care Act. But these are effectively safeguarding measures to protect from harm. That is very far from the broader welfare provisions of the Care Act and the duty to provide support that promotes welfare. This is protection from harm. And this is part, and a very important part for the local authority, of what underpins the appeal. The judge did not indicate in his judgment which he considered were the most harmful aspects for A of her relationship with her mother. And as we've seen from paragraph 70 that we've just looked at, those were not just physical and mental health harms, but social isolation, lack of independent living skills, and so on. I can tell you frankly, the local authority does not know which harms it is to focus on. Clearly, the medical aspect will, to a large extent, fall under the remit of a general practitioner, perhaps, who's not a party to these proceedings. The trust, because she will remain under the care of an endocrinologist and a neurologist for epilepsy. And it may be that the local authority will have a role in coordinating communication between primary and secondary care and facilitating an MDT. But outside that, which the judge felt were the most harmful aspects and what it was that the LA should be targeting is not clear. They can do really very little more than perhaps take A out for trips into the community and ensure that in that way she does have some trips into the community which she might otherwise lack, given the profound social isolation from which she came.
Clarification were required of that. That's something that would have come out of the discussion of the proposed plan, which would have happened a couple of weeks ago.
Lord, that might be said, and I will take you later on to the decision of Mr. Justice Baker, as he then was, which looked particularly at how this sort of difficult best interests planning could be done in a collaborative way. But what the judge did was, I think, hand down his judgment on around the 20th of March, and then within the judgment direct a one-day hearing on the 18th of April, about a calendar month later, and simply direct in the order that the state actors, if I can put them that way, go away and formulate these plans. He gave direction in his judgment for the sort of matters that he wanted people to think about in relation to the plan for telling A that she has been covertly medicated. But he gave no steer otherwise as to what he wanted to see in the plans or how the plans could be grafted to protect A from the unhealthy, troubling relationship with her mother. So,
Can you help about this? The judgment was handed down on the 20th of March. It wasn't, I think, until the 10th of April that the order was signed by the judge. Presumably he was relying upon the parties to provide a draft of the order. So it took you, Easter intervening, 3 weeks, even to draft an order. And the day before the order was signed, your appellant's notice went in, on the 9th of April. Is the sequence of events.
Yes.
Right, so the time that the judge had allocated for preparing for the sort of discussion that you're referring to at the moment seems to have been mostly spent in two things: drawing up an order and putting in an appellant's notice, or two appellant's notices. As a matter of fact.
I may need to turn my back in a moment and just remind myself of what has happened in relation to care planning, because certainly a support plan has
Appreciate
been
that the
created.
order was either stayed or had a sword of a stay hanging over it, but in practice the judge gave the parties, if his order had been followed, a period of about 4 weeks to come back with the proposals for what the implementation proposals. But in fact that time was not spent in that way for reasons that we know.
Yes.
I thought you were about to tell us that some work had gone on, notwithstanding the fact that an order hadn't been drawn. Did I misunderstand?
May I turn my back and just make sure that I give you correct and
Yes.
accurate information about this? Lords, can I take you to page 79, which
Yes.
is the last page of the penultimate page of the order? You'll see there at paragraph 2 a direction that the parties work together, and at 3 that B was to facilitate a visit to her home. That didn't happen, only I think because of pressure of time. But at 4, that B should serve and file a statement addressing her views, and at 5 that the local authority should serve a statement about how it intended to support A. All of that work has been done and was done within the time directed.
So that wasn't held up by the failure to draw an order?
No, it wasn't.
That's helpful. Just so I can understand the slightly oddly structured. We've got the declaration at 1 and 2. We've got orders at 3 to 9, and then a freshly numbered set of. This is all part of the same order, is it?
It's all part of the same order.
Yes, I see.
I think some of the first set of orders, and I agree.
It doesn't matter. I mean, what matters is the substance. I was just trying to see how it all fitted
Yes.
together.
You get a first set
These are effectively directions. These are effectively procedural directions.
Yes.
Conscript. Yeah. Okay.
So the first set of orders are substantive, giving
Yes.
decisions.
No, it makes perfect sense. I
And
just
the
haven't
second one's
worked it.
case management.
Thank you.
I think, and I'll be corrected later if I'm wrong, that paragraph 6 has also been complied with by the NHS trust, and I'll leave others to deal with compliance on behalf of A and whether that's correct.
Will you just give me a moment to look again at 4? Yes, thank you.
Miss Dollop, I suppose one of the difficulties in what is a really difficult matter is that there wasn't a final oral hearing. For no one's fault, time ran out in January at the 3-day hearing, and thus it was written submissions had to be filed, and there was no opportunity as between the court and council to ventilate any ideas or any proposals for the way forward.
My lady, I agree, and the way in which we lost time was regrettable, but just one of those things, and nothing was to be done.
Did anyone propose there be a further oral hearing for submissions?
No. We discussed with the judge how we would deal with closing, and I think we simply all agreed that we would file written closing
There's a question on over availability of counsel within a reasonable period in order to get either B's evidence finished, because on the Friday, the last day of the hearing, B was ill. There was a discussion about adjourning the matter, and then B appeared, continued with her evidence, which took us into the afternoon, but by then we'd established that convening 4 of us for an oral hearing would be extremely difficult.
No, well, I don't underestimate those difficulties.
Yeah.
But sometimes, if enough pressure is put, the difficulties are overcome.
Yes.
But there we are. Everyone agreed written submissions were sufficient. Yeah.
My lord, at that stage, and at the close of the evidence, which is where we got to when we ran out of time, the understanding of everybody was that the judge had 2 proposals before him, and 2 sets of submissions. One was on behalf of the local authority, the official solicitor, and the NHS Trust, that there be what I think one could properly call another trial, as it were, but this time a trial of residents in a supported independent living placement with the continuation of covert medication, and then a decision to be made about contact between A and B. But that was the residence and care plan that was commended to the judge by 3 of the parties. The proposal made by B, and you will recall that it is B's application that the judge was hearing and determining for the return of A to her home and sole care. B's application throughout, given notice prior to the start of the hearing, canvassed and attested to by her in her witness statement, and set out in her opening position statement, and I can find the references for all of those for you, was for B to return to B on a trial period. So the judge had before him different, but in that way similar, orders that he was asked to make. One was for a trial of supported independent living, and another was a trial of a return home. If I can take you briefly, just to bottom this out, to the written closing submissions of the local authority, which are in the supplementary bundle at page 92. paragraph 2, this document is dated the 8th of February. You'll see there that we set out what was my understanding and that of my client at the time of filing these written closing submissions, that B was not intending to provide the court with a draft of the order that she was seeking.
Don't we
Or
have
any
to look at
plan.
paragraph 1.
Paragraph 2, I beg your pardon.
No, but don't we have to look at paragraph 1 in the context of the submission that you're currently making?
Yes. That was her September 2022 application, was for a return home. And everybody always knew that B's aspiration, her intention, her strong wish was to live with her daughter and her daughter to be returned to her sole care. But at the hearing in January, what she was asking the court to order was a return home on a trial period. And it was not suggested, and it was not my understanding. I've seen what B says about this in her skeleton argument, that everybody knew that at the end of that trial period she'd be asking for a permanent return home. That was not my understanding. And one might ask rhetorically, what is the point of a trial if the outcome is going to be the same, whether or not the trial is successful or unsuccessful? You might as well not have the trial. It's otiose and pointless. What B was asking for was a trial so that she could try to convince A to take the medication voluntarily, and she said that she would have a much greater chance of being able to do that if they were in the comfortable circumstances of home and they could have what B told the court was a mother and daughter chat at home, and they would have privacy and be in familiar surroundings, not having support workers monitoring the conversation and sitting in the room with them and so on. But my understanding was that if at the end of that trial period she had not persuaded A to take the medication voluntarily, there would be a further decision to be made and all options would be considered.
Ms. Gold, can I get this clear? I've read it, but I just want to be certain. Was it the position of any party that there should be immediate cessation of covert medication?
No. My lords, just to stay with closing submissions for a moment. B's closing starts at supplementary 111. And in fact, the local authority was quite wrong. These were filed the following day on the 9th of February, and they were filed actually with the order that B was inviting the court to make, and that starts on page 131.
Sorry, I've got lost. You took reference to 101.
111 is the closing submissions.
Oh, sorry.
Behind the closing submissions
No,
is
I
the
just
draft
misheard.
order
That's
at
fine.
131.
Yep.
And you see there at 133 that paragraph 1, to return home for trial.
Sorry, I've got lost again.
Sorry.
111 is B's closing submissions.
Yes.
133 is...
131 is the start of the draft order provided to the court by B.
Yes, I see. Thank you.
So I had understood that B was not going to provide a draft order that she was asking Mr. Justice Poole to make, but in fact the next day she did so, and we can see there what it is that she was asking.
And you can see there that he just taking up the question.
Yes.
That I just asked.
I'm sorry, again, I'm being slow. What was the paragraph to which my lady referred you?
It's paragraph E. So,
Oh, 132, sorry. I was reading
132.
Yes, sir.
So these are a series of recitals.
Yes.
And Milady asked, had it been the position of any party that A should be told about, or that covert medication should cease forthwith on a return to B? And the answer is that no. This is B's draft order, and B was asking for covert medication following return home to continue during the 12-week trial period. And the lady will see at H if it is impractical, so this is the fallback position, if it's impractical to covertly medicate in the community, it's still in A's best interest for B to have the opportunity to convince her to take HRT voluntarily, and therefore to return home for 12 weeks without covert medication to see if A could be convinced. And at I, that B was proposing that it was in the best interest of A to be informed that she'd been covertly medicated at a date to be determined by the court. Whether that was in tandem with the return home, and either before or during the trial period, I'm not sure. But certainly, I don't want to have too many A's and B's, but plan A was to continue covert medication in the community. And the lady, that is then recorded on page 133 in the orders at paragraph 2. And at paragraph 3, for the local authority to provide carers who would monitor covert medication.
And 1 sets out the point you've previously been making, namely the trial period.
Yes.
In respect of 1-2, Professor Z, that in fact hasn't come to pass, has it not?
It has not, no. And you'll see that at I'll come back to why, at 6, paragraph 6, another part of B's plan was for the trial at home to begin as soon as possible to give B time to convince A to trust Professor Z. That hasn't happened. I think I am not putting things unfairly if I say that it appears to all of us that, for reasons that we don't really know, Professor Z has had cold feet about participating. She wasn't prepared to travel to or anywhere near A, and so A would have had to make really quite a long journey from the north of England down to London. She was prepared to come from the south of England up to London. We didn't even get into the fine detail of making the travel arrangements and whether that would require overnight accommodation and so on. B had arranged a 5 o'clock in the afternoon appointment in London, which was the wrong end of the day for A to concentrate, and would have meant that she has to stay here and so on. But for whatever reasons, Professor Z is no longer a person to whom assistance is asked.
Can you speak up? Professor Z is
Yes,
no longer a person
that we're asking to provide assistance, and I think somebody else has been identified much closer to, so that is still something that I think B wishes to take place and believes would be beneficial, and other parties are prepared to go along with that.
I don't want to press you further than you are able to go, but when you say someone else near a home has been identified, does that mean identified by B, or does it mean identified by the local authority?
Certainly not by the local authority, and I'm looking to others to, I think it has been by B.
My Lord, the position as far as B is concerned is that inquiries are still being made. We have not had confirmation from an endocrinologist that they are willing and able to do it. Attempts have been made to get someone in the north of England, One of the problems, as my learned friend identified, was that the local authority was concerned about a late appointment with...
Concerned about what, sorry?
The late appointment, 5:30, with Professor Z. That wasn't acceptable to the local authority. And therefore we had to look elsewhere. So we're looking at endocrinologists, consultant endocrinologists in the north of England. However, there aren't many of them. And that's one of the problems. And one of the issues, of course, is will they be able to be acceptable to A? And that means, although there are some near Newcastle, A is likely to find.
I don't think you meant to mention the place.
No, I won't. Sorry, my lord. If there are some in parts of the north of England that I think perhaps we ought to avoid because they are places where Dr. X is likely to have influence. B has no objection to those people, and I think that must be emphasised. The problem, the fear, and we don't know, is that A may have objection if they are in a part of the north of England which A feels is too proximate to Dr. X. Concerning whom she's obviously taken a view.
Okay. Thank you. Yes, Mr. Hart.
My lords, my lady, what I was intending to do was to take you to some of the paragraphs of the preceding decisions of Her Honour Judge Moyer and indeed perhaps Mr. Justice Poole, just so that you have in mind the difficulties that there have been for the local authority in working with B over years rather than a short period of time. That may or may not be useful. It may be better if I simply give you some of the paragraph number references.
Very much in your hands, Ms. Dollop. You can take it that we have read the material, but if there's things you particularly want to emphasise, you must do so.
Certainly. I think I will briefly if I can.
Yes.
Starting with the June 2019 judgment, which starts at page 115 of the bundle.
Are we still on the first of your three reasons?
They all really overlap, but we're still in the sense looking...
Well, your first of the reasons is that you object to B as being the messenger for reasons which are perfectly obvious. But are you now going to give us a list of all the disobliging things that have been said about B by the judges down the ages? I mean, I just have an eye to the time.
I understand. This is really a point that goes to the ground of appeal that the order made is unworkable and can't be put into practice in any effective way.
I don't want to be in any way fussy, but when one's told there are 3 points, one needs to know what they are when one's moving from one to the other.
I'm so sorry. I had meant that there were 3 points in relation to covert medication. I was trying to set out to start with, in summary, the difficulties and the reasons why the local authority says that the judge was wrong. I have done that now.
Well, could you just tell us, the first is that it makes B the key messenger. Understood that. What's the second and third?
The second is that it appears that the judge's intention is to conceal...
The deception. Right, okay. The second point is the deception.
And the third point is that if the deception that that her mother is somebody who is trustworthy and has effectively her best interests at heart.
The trust paradox.
The trust.
Yes, then the restoration of autonomy is not effected.
Yes.
There is no autonomy.
Yeah,
That is the third point.
Right, so true autonomy would be to see her mother for what she is.
I don't know if that would be true autonomy, but I don't think that one can say, and the judge has found, that the part of the benefit that there is to his disposal is that there will be a restoration of autonomy. And we've just seen the part where he thinks even perhaps autonomous decisions in relation to medical treatment will be affected by her being told that she has covert medication, but on a basis that is partial, incomplete, and untruthful.
Well, that's helpful. So we know what the 3 points are. Now,
Yes.
you were about to do the exercise. I'm, as I say, you're master of your own submissions. And if if you want to take us to these passages, do. But we haven't interrupted much, so I think you will need to stick to something like your timetable, unless there's a considerable saving in not having to deal with the guidance.
Well, perhaps I'll give you some paragraph numbers, and I'll just
Yes.
take you to one reference, because I think it
Yep.
does explain. It's paragraph page 115, which is the first judgment in these proceedings that we have from June 2019.
Sorry, page 100 and...
It,
Oh, I know. Sorry, I've got the... Whereabouts in the judgment are we going?
Yes, over the page to 117, paragraph 4 and 5. At paragraph 4, you see 2 lines down. It says it was the local authority's original intention to work with B to enable A to remain at home whilst treatment was undertaken and services provided to meet A's needs. And its plan then changed. And at paragraph 5, it was recognised for the plan to be effective, B would need to encourage and promote such support as being helpful and positive to developing A's experience and development. And over the page, A would be unlikely to engage if she perceived her mother to be opposed to the arrangements. I'm afraid to say that over about the 5 years that have followed, it has been the local authority's experience that B does not encourage or promote such support, and she is opposed to the arrangements. And even under supervised contact and in the run-up to a 3-day hearing before a High Court judge, she effectively makes remarks that undermine efforts to support A to have any kind of independence or gain a greater sense of herself.
I think I discovered somewhere what the frequency of contact has been since it was resumed in November, but could you confirm it?
Yes, I will. I think it's twice a week in-person visits,
Yes.
and we think about 3 times a week telephone contact.
Half-hour phone calls. Yes. It's 2 or 3 hours the visits, and half an hour or so the phone calls is where some of it.
Yes. And that's what's provided for. There are times when A chooses not to be available for a visit.
My Lord, I hesitate to interrupt, my learned friend, but I think it is relevant to the particular point that my Lord raised, that there is, on my understanding, has only been one contact face-to-face since the 1st of February, save there was a very brief contact, I understand, at a funeral where A arrived late for the funeral with her carers. In fact, it had finished. And then she was taken back to the care home. Other than that, there's only been one since 1st of February, my understanding at this point.
So what's the significance of the 1st of February? I think my Lord said, and rang a bell with me, that the resumption was officially in November.
It was. There was...
You're saying that in November, December and January, something like December and January, something like the contact provided for happened, but it's tailed off since the 1st of February, is that it?
Not quite, my lord. I'm talking about recent contact. So this year, contact since the 1st of February happened once in the sense of a full, proper face-to-face meeting. There were problems all the way through last year, particularly towards the latter end of last year with contact. And I won't go into the detail.
Well, I would have thought it's unfair to Mr. Gollop to. We may well be interested in this, but why not make the points during your own submissions?
Yes, well, in that case.
You put down a marker that's.
I apologise. I'm only putting a marker down about the
got the
number
marker.
of times people are in contact. It's not quite what it was arranged by the court to be.
We've got the marker.
I'm grateful.
Lord, I should say that regrettably there are likely to be disputes about what you are told on behalf of B about what has and hasn't happened at contact, reliability of
Well,
and
the
frequency and
judge
duration and so
didn't
on.
resolve those disputes.
No.
I'm not sure that we need to,
Well,
but
quite. Just following through with this judgment, if we may, paragraph 14 at the bottom of 121. That B hadn't been involved in the development of the plan, but B had said that she doesn't want a social worker or support services, and it was said that a discussion with B at this time in respect of these matters had not proved beneficial. Moving on to paragraph 65 to 67 on page 146. One of the matters that Her Honour Judge Moyer was asked to deal with was the validity of a document which was handwritten and which was put forward as being A's living will or a statement of her wishes. And you can see at the top of page 146, it's dated the 6th of March 2018. I want to live with my mother. I don't want to be in hospital. I don't want to go to outpatient appointments. I don't want social services in my life. I don't want a social worker. And effectively wanted attorneys to be empowered in all regards. That was put forward by B as a document that A had capacity to write herself, and the judge found at the end of paragraph 66 that A did not have capacity. And at the bottom of the page, in paragraph 67, the judge found that on the basis of the evidence before her, it was unlikely that the wishes and feelings expressed by A in the document or any other expression of wishes and feelings are her uninfluenced views. But she has consistently articulated clearly that she wants to stay with her mother with no outside interference by social workers or the court.
what's the particular point you're making?
The point that I'm making is that nothing has changed in this regard, and the judge's order that A now be returned to live with B, who influences her views, her wishes and her feelings, and the local authority provides her with protective measures that protect her from the harm that flows from the relationship, is unrealistic and unworkable, not practical, and not something that can be delivered. It's not something being able to deliver whilst A was living with B in the past, or whilst A has been living in the care, if I put it that way, or accommodated by the local authority, and in circumstances where B has not changed, as the judge found that she has not. We cannot see that we have any hope of being able to mitigate or protect. And although a plan has been created as directed by the court, it is not a plan that the local authority considers has any real prospect of providing A with the intended benefit.
Is the plan amongst our papers?
No, you don't have any post
No.
decision papers, I'm afraid, but they could certainly be provided.
Well, the plan we're talking about is the plan that has been proposed pursuant to the judge's order, as you explained earlier. But it's not in any sense an agreed plan. It's the one that we haven't got any observations on it from B. Is that right? Has it been shared with B at this stage?
Yes, it's been filed as directed.
Yes, I see.
At paragraph 94 on page 162. The least restrictive option, in the local authority's view in 2019, was to attempt to provide support to A within her home setting. View changed following evidence heard in court in March, and Miss V, who is the social worker, questioned the likelihood of any plan to increase socialisation, social network, community activities, and greater independence being effective if A remained at home. That was the fear then, and I'm afraid it is a fear that has been borne out. The past is, in this case, a strong guide to the future. Briefly, the next judgment from June 2020. If I take you...
Just 1 moment. My Lord is concerned, and I share the concern, that we haven't yet got to the grounds of appeal, and you're drawing our attention to passages which merely emphasise what Mr. Justice Poole already found. Up to you, and I do wonder, as I say, whether you are in a position to borrow some time from Mr. Karim if you need it. But if you're not, we will need you to focus on the grounds of appeal at some point.
My Lord, yes. I have deliberately written quite a full skeleton argument.
Yes. Well, up to you, but
I understand. In a sense, I hope that I am addressing the grounds of appeal, but this is not an easy case in which to divide up different concepts because they generally tend to overlap. So I am hoping to get there.
Well, I'm just putting it out. Let's not spend more time discussing it. Or we
yes,
won't.
Of course.
But no, let's see how we go.
There are some points that I would like to make about the fact that B has not changed, and I will do those as compendiously as I can, perhaps by simply giving you references rather than taking you to documents. And these are points in B's skeleton that in my submission need to be contrasted with the judgment where they are directly addressed. In B's skeleton, at paragraph 12A, B says that, in retrospect, A may have lacked social engagement. That needs to be contrasted with the judgment at paragraph 34, little 3, where the judge makes it very clear that this is not social isolation seen in retrospect. It was happening in real time, and the A must have been aware of it. He says that Mr. Justice Poole, asked B about A's interactions with children her age, and B went on to accept that A had had no peer friendships or contact since about the age of 9. That's not a matter that's seen in retrospect. It was a matter that can only have been apparent to B at the time. Also, in paragraph 12A of the skeleton, in the last sentence, B says that it is not true that the allegations that were made by neighbours and reports were made by neighbours to the local authority that A only went out at night. B says that isn't true. The judge doesn't deal with it directly, but he does deal with it in the judgment at paragraph 34, little 9. And he says, when asked about this, B discounted the reports as being malicious. These were reports about A's isolation. It's clear that the judge was not persuaded that they were malicious, but B continues to assert that they were. At 12B of the skeleton, B discusses vitamin D deficiency, and what B says in her skeleton is that it's suggested that the vitamin D deficiency is attributed to B. Indeed it is. And then B says, quote, the only fact is that the deficiency was ascertained by a doctor. That's simply not right. The judge deals with this at paragraph 34, little 2. B told the court that she and A had both taken vitamin D supplements, but the evidence is clear that A had a vitamin D deficiency when in B's care. At 12C and at 12F, B comments on the fact that the local authority says that, encouraged by B, A declined to take HRT and continues to refuse it, and says that that could lead my lords and my lady to apprehend B's position. This is one of the points at which B asserts her position. And that in any event, at the hearing in January this year, B's position was that she had the best chance of convincing A to take HRT. This also comes up at paragraph 30 of B's skeleton. But the judgment at paragraph 53, at lines 7 to 11, is clear. Although B says that she supports A being given hormone treatment, her actions do not match her words. She has supported her daughter to refuse the medication in the past. She has not, even now, fully or genuinely accepted responsibility for that. She hasn't taken the opportunity clearly and consistently to persuade A to take the medication. That's even during the contact in all the time that A has been living at placement A.
In a sense, you're making your own difficulties here, aren't you? The judge was fully aware of all these points, took them on board, and yet reached the decision that he did.
My lord, yes. In terms of health, the practical difficulty here, and I fully appreciate that one could say, well, the judge has looked at it all and decided this is the correct best interest, final and permanent disposal in any event. The local authority's position is that what he has ordered is a return home with, not of itself. If he had said A is to return home to her mother, if she doesn't take HRT while she is there, then that is a price that has to be paid for her wishes and feelings being given effect to, and her living in the place of her choice, rather than being deprived of her liberty accommodated by the local authority. And that effectively everything that had been tried to support her, to gain some independence, be less socially isolated, not be confined to the house during daylight hours and so on. That might be one thing, and that would be a different disposal. But in a sense, what he's ordered is neither fish nor fowl. It's not making that decision and giving that effect to wishes and feelings. It's saying, I'm going to do that, but I charge the state with protecting from all the matters that it's been unable.
Speaking for myself, that's not how I read the decision at all. I think your summary of what the judge might have said is actually what he's saying. But he's not pinning this on how successful you might be with all the services that you and the trust would provide. He's directly accepting that this is the less worst, less bad option of the ones that faced him. That he's not pinning his decision upon what the support services will be. He's just put over what they are going to be. But it wouldn't be realistic, would it, for him to say she can go home with no HRT and that's an end of it? Because that, from a point of view of a reasoned decision, would not be a sensible way of proceeding. To effectively sign off on all efforts to help. But in the end, the judge has made the decision, as I read it, that B will go home with whatever help can be provided, and we'll see how it goes. And the local authority will form its views, the health professionals will form their views, and life will continue to whatever end, uncertainties which he flags up in the very opening paragraphs. So I just want to register that you say, if the judge had said this, that would have been all right. Speaking for myself, that's what he is saying.
If my lord is right, then that may make life clearer for the local authority. But the words used that he's ordered are protective measures.
To mitigate the harms, insofar as they can be mitigated. I mean, as my lord has said, all the material you've been showing us is material that the judge accepted.
Yes.
And it was a centrepiece of his decision that B could not be trusted to behave differently in the past than the way she behaved in the future. But he nevertheless thought that this was amongst a poor field, the one that he chose.
My lord, I would respectfully suggest that he is, in effect, he's giving me an opportunity to convince A to take HRT. But as he makes very clear in the judgment, there is simply no way of knowing whether she will or whether she won't. It's
clearly not a right reading to the judgment to say he was sending her back in order to see whether this was in order effectively to get her to take HRT. That would be a great benefit if it happened, but the judge makes it clear that he thinks she should go back even if that doesn't happen. Though he also says that of the small chances that she will change her mind, that's most likely to happen if she goes home, or least unlikely if you prefer.
My lord, yes, I understand and agree. I was responding to observation that if the judge had said, well, go home and that's an end of it, that would not have been a sensible way of proceeding. But I think there is, certainly in relation to the health aspect, there is no other way of reading the judgment because it is not possible to know whether she's taking HRT for the reasons that he discusses. Blood tests are unavailable, and we will never know whether she is having epileptic fits at home either. B suggests that it's going to be possible, B says, for the local authority to monitor these matters, and B says this in a skeleton at paragraphs 4, 6, 33, that if A is fitting more, the local authority support workers who see her weekly will no doubt become aware of this. They won't know. They'll have no way of knowing. And I think both conditions are likely to revert to being uncontrolled. That may be that the judge is saying that is, again, a worthwhile price to be paid given the difficult balance. But it is difficult to understand what protection or mitigation from harm the local authority can effectively provide.
I think becoming clearer, which I hadn't fully picked up, I probably should have from your skeleton argument, that your submissions perfectly understandably are motivated by a concern that the local authority may be put in an impossible position, or a position where what it can do is ineffective, and therefore why should it be doing it? It'll just create a great deal of difficulty and concern for the local authority, which for no purpose. But it's very difficult to judge that in the abstract until we see what plan the judge approves. If you put forward a plan that you think is the best that you can do and you don't think it's achieved very much, that's what you will do, and the judge will take a view on it at the hearing. He may say, well, I agree with you, it may not achieve very much, but if that's the best you can do, that's what you'll have to do. Or he may say, no, there are more things you can do, and suggest what they are and have a discussion about them. But arguably, the concern that's becoming clearer from your submissions will be better argued in front of the judge with a positive plan in front of him than before us.
My Lord, that's one way of looking at it. I think that the difficulty with that is that this is a step that we think properly could and should only have been taken before the final decision was made. Not least because there's an interconnection between the protective measures that the judge has charged the local authority and the trust with providing, and his other order that A is to be told that she's been covertly medicated. There will, it seems, be loss of trust. The trust in B will be cemented. B's will inculcate and repeat the advice that she's given to A all her life. You don't need social workers. You mustn't trust professionals. Only trust me. One can see that in the parts of the judgments that I've taken you to from 2019 onwards. And it's difficult for the local authority to know where to go and what we are to build into the plan in relation to an order that is enforceable. And we don't think that this is simply just the judge saying, I've made my decision, we'll have a one-day hearing while I look at the plans, and then we'll have another day hearing after that if I think they all need to be worked out again. The judgment seems to us inconsistent and not coherent.
Yes.
Because we are charged with protection against a background of harm and trust being cemented in the person who is the source of harm in circumstances where irreparable damage will be done to any trust there might be in the future in professionals. If the only way of having any sort of enforcement in the future might be for A again to be removed from her mother's care, I don't know what circumstances that might be applicable in. It depends on how the support is to work and what the health detriment
You'd have to establish it on normal principles, on evidence before the court.
But at the point that one might be thinking about that, and suppose such an order were made, having been told that she's been covertly medicated and having lost all trust in professionals, you're not then you're starting from an impossible position in providing her with...
Very, very difficult. But I mean, just one question. What are you asking this court to do about the judge's order? Set it aside?
Yes.
And?
Remit.
Remit to a different judge to make the whole decision again? After everything, I mean, this is a dynamic situation. B has been told about what is happening. A has not been told. But the situation doesn't stop in January. So you're suggesting that this trial process should be done all over again?
We can't see a different way around that, given the interconnection between the telling A decision and protecting her from the future and leaving her with any sort of an open future. We think that by telling her all future options are closed down, and really the only future option that's left with her is remaining with her mother.
In the meantime, A is left in not being told about the decision that's been taken. Continue to be covertly medicated for what, on the basis of the progress that this case has made, it's been going on now for 5 years, will be months and months.
Well, my lord, we're acutely aware of that, which is why, and we're grateful for your assistance, we brought this appeal on as quickly as we possibly could. But the local authority understands that there are positive and negatives to every decision, but thinks that this is not the least worst outcome, and that...
Well, I appreciate that you don't think it's the least worst outcome, but the judge did.
Yes. We simply think that by telling A about the past, it might be different if one was not to tell her that she'd been covertly medicated, and her mother does the best that she can, or one tries with Professor Z to see if the second...
So the mother has got to comply with directions that she's not to talk to her daughter about covert medication, she's not to talk to the daughter about the trial or its outcome, or the appeal. And then that's to go on for a further indefinite period until this can be reheard. I mean, you've been talking about deceptions. Of course, deception is needed if it's clearly in the interests of a vulnerable individual. But the deceptions that have been carried out on A, in this case, are at the top end of the scale.
My lord, I suppose an alternative is to set aside the decision in relation to telling A that she has been covertly medicated and trying other, arguably more proportionate ways forward, such as going to see an independent expert
What
of
happens
her
to the
mother's
proceedings?
choice.
What happens to the proceedings in the meantime? Do they go forward in front of this judge? So he's made it perfectly clear that the whole architecture of his decision about residence and telling A are all part of the structure.
Yes.
What happens to the proceedings if you start breaking them down?
It means delay, and it means a longer period for A living in placement A. And it may be that the better on, perhaps the other parties one sets aside that part of the order that requires the local authority to provide any sort of harm mitigation method.
But as to that, I can appreciate that you're sensitive about this, but the court has made a decision. You have the same responsibilities towards this particular individual as you have to a lot of other people who have unfortunate difficulties in the community whose circumstances are highly unsatisfactory. But you can only do what you can try to do. How could anybody blame you for professionally taken decisions in circumstances that were ordained by the court?
Now, that's been a very helpful exploration, but you have...
I don't think that I can usefully say very much more, and the other grounds of appeal are substantially set out and have generally been canvassed.
No, your
All I've said to you
certain arguments, if I may say so, was admirably clear. And those points that you haven't developed already, we will nevertheless give full account to.
My lords, yes. The answers that I've given in relation to the disposal that I'm asking you to, the relief that I'm asking you to grant on appeal, are matters that I should properly discuss with those sitting behind me, and will do so over the short adjournment, and perhaps say something more. No doubt those sitting behind me will want to reflect on what I've said.
Yes, well, we will certainly make time for any updating of your position on that you want to give.
Right.
Well, thank you very much,
Thank
Ms. Dollop. It's been helpful. Mr. Kareem, I don't feel, and Ms. Dollop needn't feel guilty about taking some of your time, because you don't obviously know what you were going to focus on in your oral submissions, but certainly a substantial part of your skeleton was about guidance, which we have expressed an interest in not giving.
Yes, my lord, yes.
So it's really you making any points over and above those made by Ms. Dollop, or developing points which you need to, but you certainly don't need to go over everything from scratch.
Yeah, I'm grateful, my lord, my lady. My skeleton argument sets out, under the heading of legal framework,
Yes.
the relevant provisions of the Mental Capacity Act, in particular Section 1 and Section 4.
Yes.
My lords and lady, this appeal, as has already been demonstrated, exemplifies the tension between protecting people and promoting their autonomy. And it is something which every judge in the Court of Protection has to do on a daily basis when they're making a best interest decision pursuant to Section 4. Whilst the official solicitor supports the grounds submitted by the local authority, it does so on this basis, that it is the Section 4 determination that Mr. Justice Poole has made that, in my respectful submission, is wrong. And I exemplify that by 5 different decisions that he's made. And I accept that is a discretionary power that he exercises under Section 4, and so the threshold is high for me to overcome. But those 5 or 6, forgive me, points are these. And similar to the grounds that have been put forward by the local authority. First, he erred in exercising discretion, making a final determination on residence and covert medication. Second, he conflated the decisions of residence and medication.
Hang on 1 second. Yes.
Third, it is difficult to reconcile some of the issues that he had regard to in making a best interest determination. And when I say some of the issues, what I mean by that is reasonable circumstances that he is obliged to take into account pursuant to Section 4(2) of the Mental Capacity Act. And those are that there was no...
Sorry, I'm very rude of me, but can we have what the headline point is, and then you said he difficult to reconcile what with what?
Difficult to reconcile 2 points. That there was no consideration of B's ability to meet A's needs at home, number 1. And number 2, the established enmeshed relationship that A has with B and vice versa.
Why is it difficult
to reconcile, my lord, in the sense that the decision's been made that A returns to reside with B, and that is difficult to reconcile when there's been no...
Oh, I see. It's difficult to reconcile a decision to move to let her go home with... I see, sorry.
Forgive me. Fourth, my lords and lady, that there's been inadequate consideration of, or the rationale to cease covert medication and inform A that she's been covertly medicated. Fifth, the insufficient balancing exercise of the competing ECHR rights, namely Article 2, 3, 5, and 8.
Does that add anything? That's just a legal label for the substantive points, isn't it?
It does add something, my lord, because if I submit a proper approach or a balancing exercise was undertaken, considering the competing Article 2 and 3 rights which the judge concluded were engaged with Article 5 and 8, then that would have fed into the best interest determination in a different way, in my respectful submission. or at least weight, different weight would have been placed on.
It's quite an alarming submission that in a case which is so fundamentally about welfare and rights, that it would feed in a different way. Surely these principles are all meant to be feeding in the same way.
Well, my lord, perhaps different way was.
What do you mean by they would feed in a different way?
It's a matter of weight. So
well, if it's a matter of weight, then you're in trouble, aren't you? Because it's the judge to decide what weight to give to the relevant considerations.
But my lord, when I
why would you give more weight to them if they're given an Article 5 label or an Article 2 label?
Well, my lord, when I developed this point very briefly, there is no consideration of the competing weights between Article 2, 3, which he said was engaged, and Article 5 and 8. That, had there been one, in my respectful submission, would have fed into the best interest determination under Section 4.
He would have been bound to give more consideration to the former two than to the latter two. Is that what you're saying?
Essentially. My lord.
Is that because they're called 2 and 3?
No, my lord, because those are
because
rights
the facts underlying them,
which can't be.
Which was that the non-derogable.
My lord, yes. Whereas
But that's
5 and 8 are qualified rights.
that's sorry. Let my lord.
So we've teased out the point, which is that because they are unqualified rights, he was bound to give more weight to 2 and 3. I thought that on the whole, when one was approaching a matter of this sort, that the particular rights didn't have presumptive precedence, and it all depended upon looking very closely. But you're saying that actually 2 and 3 should have been given a head start because of their terms, in their own terms.
My lord, yes, and relevant for the Section 4 determination of what is in A's best interests. And finally, my lords and lady, there's been a specific failure in my respectful submission to consider the weight to be given to A's wishes and feelings under Section 4.
If I may say so, I don't mean this rudely, it's just a shorthand. It's rather weasel words of failure to consider the weight to be given. You really mean gave too much weight. It's clear he did consider the weight to be given. But you think it gave too much.
Gave too much weight, my lord, yes.
Yes. But I said the reason I say weasel wording, which I said isn't as rude as it may sound, it enables you not to face up to the fact that matters of weight are for the judgment of the judge.
But, my lord, yeah,
I mean, where can you point anywhere in the judgment where he fails to consider the weight to be given to her wishes? He clearly does give weight to it.
But, my lord, yes. What is
your point that when giving weight to it, he doesn't, I think expressly, I may be wrong about this, doesn't expressly say these are the wishes of someone who the court has found hasn't got capacity?
Well,
is that your point?
No, my lord, in my skeleton argument, I set out some case law, and my skeleton is found in the core bundle at page 59 onwards.
Yes.
And the relevant paragraph is paragraph 14 at page 63. And this is a well-known decision, if I can put it that way, which provides some observation of how much weight one should put into P's wishes and feelings, that being a mandatory requirement under Section 4(6) of the Mental Capacity Act. And some of those considerations include, obviously, firstly accepting that P's wishes and feelings should be given a significant weight, and the general observation that it ought to be case-specific and fact-specific. But there are observations in the third category over the page, my lords and lady, in relation to the degree A of P's incapacity. The nearer they are to the borderline, the greater the weight that should be placed on it. The strength and consistency, possible impact on P of knowledge of that her wishes and feelings were not being given effect to, and the extent to which P's wishes and feelings are rational, sensible.
Yes, well, certainly the first three tend to increase the weight which the judge should have been giving, or more accurately, tend to justify the degree of weight to which the judge, don't they? Oh,
But yes, so when one is
so
considering...
what's the point you're making based on this authority?
So the point I'm making, my lord, is if I could take you to the authorities bundle, perhaps if I go back to basics in terms of what Section 4 requires, the authorities bundle at page 34...
Yes, I'm sorry if I'm taking you out of your course.
No,
I didn't mean to do that. I just wanted to understand the solution.
Not at all. Page 34 in the authorities bundle sets out Section 4.
I'm sorry, Mr. Kelly, I was actually looking at another document. What page?
34.
Which page you asked us to
34, it begins.
34, yes, thank you.
Yes. And it's paragraph 4.
Yes.
And paragraph 6.
Yes.
Subparagraph that he must consider, insofar as reasonably ascertainable, the person's past and present wishes and feelings.
Yes.
And consider further down at paragraph, further up, paragraph 2, so 4.2, the person making the determination must consider all the relevant circumstances. Yes. So the point I'm making, my lord, is that there is a mandatory statutory requirement to have regard to P's wishes and feelings, and the case that I've just referred to talks about how much weight you then place on that requirement in the best interest determination.
Well, I get all that, but that's all where we start from. What's the point? What did the judge do wrong?
Well, my lord, he didn't actually consider how much weight to place on A's wishes and feelings. He just took it as read that significant weight should be placed on it.
Well, I don't know what you mean he didn't consider. In order to decide that significant weight must be put on it, he must have considered that was the right thing to do. Well, are you saying there should have been a paragraph saying how much weight should I give, and then calibrate it between 1 and 20? I mean, I don't see...
It's a relevant consideration in this case that, yes, he should have done that, bearing in mind the nature of the relationship between A and B. And if I could just explore that concept in a bit further. There are, in my respectful submission, 4 issues of magnetic importance when looking at those grounds which I've outlined.
Yeah.
The first is the enmeshed relationship that A has with B, and my learned friend for the local authority has set it out in some detail. But in terms of what is said in the judgment, if I could just take my lords and lady to that, the judgment commences at page...
Would you mind giving us the list of 4 before we go into each of them individually? What are the 4 points that you're just about to make?
Enmeshed relationship with B. A's life has been dominated by B. Yes. The optimal, goal for A is to take the HRT medication voluntarily. And A's wishes and feelings are bound up with B. And so caution should be placed on placing too much.
In the end, you said a moment ago that something about significant weight being given to A's wishes and feelings. Do you say that the judge did give significant weight to A's wishes and feelings?
My lord, yes.
Are you saying that he shouldn't have done?
He should have given less weight to it, my lord, yes.
Your client's wishes and feelings?
Because of the enmeshed relationship which he found to exist.
Right. Now, your client is somebody who is towards the upper end, the very upper end of incapacity.
My lord.
In terms of her capacity, particularly being interfered with by her relationship with her mother, rather than by her own individual capacity intrinsic capacity.
Yes.
So she's in that category. But why should less weight be given to what she feels? It's not just about wishes, it's about feelings. Why would she feel any less sorry about being away from her home than you and I would?
My lord, it's the wishes.
It's not just wishes, it's feelings.
Wishes and feelings, my lord. But
so why do we focus on the wishes?
My lord, it has to be read against the context of the factual matrix of this case. And the factual matrix of this case, which the judge found...
But can we just stand back from this? I see exactly your point. If I say so, you'll make a little... I don't think your 4 points are really all the same point. It really boils down to this, doesn't it, your submission, that the judge should have placed less weight on her wishes and feelings, which are perfectly clear and strong, because those wishes and feelings were, as he found elsewhere, to a considerable extent, the effect of her mother's dominance over her. That's really your point. And you say, well, do you say he didn't realize that that was the case, or that he did realize that was the case, but didn't qualify her wishes and feelings enough?
My lord, the latter.
Isn't that just the sort of thing as an appellate court we shouldn't be interfering with?
Well, my lord, in these stark circumstances, which are stark, and the balance of risk, as the judge accepted, I believe at paragraph 84 of the judgment, page 112, were finite. There's risk in either option, and he identified that quite well. But against the construct of him having regard to the evidence of the consultant psychiatrist and the previous findings of fact of Her Honour Judge Moyer, that the boundaries between A and B are blurred, and my lord, the reference to that is paragraph 69 of the judgment at page 108. And then that is demonstrated by way of the shared phobia that A has in respect of anybody who has a Northern Irish accent, and the mutual retreat into the confines of their own home. And finally, that in his words, directly quoting from this paragraph at 69, each has become deeply emotionally and reliant on the other, such that they lack independent individuality.
Yes, well, but you're certainly undermining any point you might have. The judge wasn't aware of these points.
Absolutely, yes, and
but you're not. That isn't your point. Your point is he should have reached a different conclusion if he properly had taken account of them. Yeah.
My lord, and it comes down to weight in a very, very difficult, as I've highlighted and exemplified in the skeleton argument, very difficult, finely balanced best interest determination. But having said that, that is of significant, or that is of magnetic importance, that there is no boundary between A and B. A's life has been dominated by B, insofar as that she only achieved puberty in her early 20s by reason of a refusal to accept the diagnoses and the treatment. And by reason of that, she was moved away from her home and her grandparents. So these are significant considerations which should have been given proper weight, in my respect.
More weight.
More weight. In the best interest determination.
Yes, thank you. Well, thank you. We teased out exactly what the point is, and I see exactly how you put it.
My lords and ladies, I don't intend to go through the specific references in the judgment which refer back to the previous determinations of Her Honour Judge Moyer. Suffice to say, if I can just briefly outline those 6 grounds that I initially considered.
Yes, certainly.
Or set out. The first is in relation to the final decision not being appropriate. My lord, you've heard some evidence, some submissions in respect to the previous position before Her Honour Judge Moyer. Her Honour Judge Moyer, as Mr. Justice Poole accepted at paragraph 8 of the judgment, page 84, determined that A did not voluntarily take medication because of the arrest relationship. That's the starting point in my respectful submission. That connects with what Mr. Justice Poole provides for at paragraph 31, when he talks, and it's, if I could ask you to have a look at paragraph 31, at page 101.
Yes.
Which
Paragraph do you say?
31, my lord.
If it's 101, then it isn't 31.
Sorry, forgive me.
It's 97.
97. Was the electronic pagination.
Okay.
Here, the judge refers to the evidence of Dr. X at the hearing, that there was an elephant in the room, which was B's role in achieving the outcome of A taking the medication voluntarily, and that A would not accept as genuine any encouragement from B unless he apologized, apologized for her mistake, and that her sincere recognition of past mistakes had been made. If I could then jump to the
That's
analysis.
not a finding, by the way, is it? That's Dr. X's opinion.
Yes, my lord. In terms of the judge's analysis of that evidence, that's found at paragraph 53 at page 103.
Yes.
Where he records that evidence, and halfway down the paragraph says, in my judgment, Dr. X's observation has considerable force. My lord, the next relevant part is the evidence that B gave at the hearing, which commences at paragraph 34, page 97. And the first paragraph provides that A said in evidence that she accepted that she would apologize in the terms suggested by Dr. X.
Yes.
The final part of this puzzle, if I can put it that way, is at paragraph 63 at page 105.
Yes. Any particular bit of it, or?
And it's the penultimate sentence, my lord. Which is that the best chance there is, this is the judge's view, there is of A beginning to take the HRT voluntarily is through B's intervention. Their enmeshed relationship means that A is more likely to listen to B than anybody else. If B can explain to her that the use of the HRT has been beneficial to her, and that she, B, was wrong not to have encouraged her to take it previously, then there is a small chance that A might choose to take it.
So what's your point?
My lord, my point is that the judge erred in making a final decision on respect of residence and covert medication before that apology had been made, and before my lords and lady, the independent expert, or not the independent expert, but the further expert, then intervened to consider whether he or she could assist in taking the medication voluntarily.
Can I park for one moment the independent expert? Because speaking for myself, I don't think that's going to be straightforward given the history of this matter. But going to the issue of the apology, isn't that something that would be built into the HRT disclosure plan? Isn't that really envisaged in the judge's order?
The apology, my
Yes.
lady, it has been suggested by, has been ordered by the judge to be made.
Yes.
But in my submission, prior to making a final determination on where A should reside, A should be given the opportunity of her mother apologising to her to see if she would then voluntarily take that medication. That being one of the optimal results that I made, that I spoke of at the beginning of my submission.
So where does that take us? That it takes a period of time X for this apology to be delivered,
Yes.
for people to look around and see what effect, if any, it's had, for everybody on a professional level to write it up and offer opinions, to come back in front of a judge, and for him to consider, and then for everybody to argue about whether, if it is highly likely A continues to refuse to take HRT, she should go home or not. Is that the course the official solicitor envisages?
No, my lord, the official solicitor envisages that A should be given all opportunity to take the HRT voluntarily.
Yes, but at the moment, the judge, are you saying the judge was not entitled to reach a conclusion after all of these years of litigation that A was unlikely to agree to take HRT medication, regardless of anything B might do, sincerely do, pretend to do, go through the motions of doing? Are you saying the judge was not entitled, after all this time, to reach a conclusion that it was very unlikely that this young woman would voluntarily take HRT?
Well, my lord, the judge has decided that one of the main reasons, if not the sole reason, why she's not taking it is because of their enmeshed relationship.
No, but I'm asking you a different question, which seems to me to be the more apt question for an appeal of this sort. Are you saying that the judge was not entitled to reach the finding that he reached, which is effectively that there's a small chance, whatever way you look at it, of this person taking medication that's been recommended? Is he not entitled to reach that conclusion on the basis of all of this mountain of evidence?
My lord, he may have been entitled to have reached that decision, but when it comes to making a Section 4 determination as to what is in her best interest, she should be, or when I say she, A should be given the full extent of the opportunities to allow her to take
We've
the
been here in other cases. Is this not a classic example of everybody going on indefinitely in order to try and find a perfect solution in which everything is known about everything? Sometimes one just simply has to make a decision on the basis of what is capable of being known and accepting that there are risks for the future. It seems as if there's a perception on the appellant's part that a judge can't take a decision unless a judge knows everything about everything.
No, my lord, my lady, my principal position is that in undertaking his Section 4 determination, he was wrong when it comes to this ground to have made a final decision in respect of residence and care when he accepted that the only reason that A was not taking the medication was because of their enmeshed relationship, her enmeshed relationship with B, number one, and number two, that if B had the opportunity to explain the benefits and make the apology, and he finds that that could make a difference. So why not give her the opportunity? Allow mother to.
And then you're arguing about sequencing. I mean, you wanted one sequence, the judge chose another. But unless you're able to persuade us that he was not entitled to choose that option, what can we do?
Well, my lord, you can conclude that in the round, the Section 4 determination on A's best interest was flawed, and by reason of the 5 grounds.
So, while I'm interrupting you, what does the official solicitor say should happen to this decision?
It should be remitted, my lord.
To whom?
I'll have to take final instructions on this, and perhaps I can come back to
I know, but I mean, you've already got the most senior judge in the region.
Yes.
So it's to be remitted to another judge, presumably. For what? For the whole thing to be done again?
My Lord, plainly, the court will only do that if it's satisfied that the grounds...
No, but I want to, I mean, you and the local authority have launched this appeal.
Yes.
I quite understand that you don't agree with the judge's decision, but surely each of you should know when you're launching the appeal what you say should happen if you were to succeed. So at the moment I don't have a clear view other than simply set aside the judge's decision and give the whole thing to another judge to start all over again.
Well, my Lord, when I say go back to another judge or remit the decision, the proper sequence, as I say, and adopting your phrase, is that apology should have been allowed to have been undertaken. If the court deemed necessary, then another expert brought in to convince A to take the medication voluntarily, and then final consideration as to whether or not that medication should be given covertly or not, and then go on to residence.
What's your time estimate for how long all this queue of questions is going to take to answer? Because at every stage one can say, well, we've decided that, now we'll go on and consider that, and then we'll need to look at that. And that's what's been happening in this case so far.
My Lord, delay is an inevitability, but that shouldn't deter, in my respectful submission, from what is in A's best interests. And in my submission, had that sequence been followed, namely allowing A to have the apology from mother because of the enmeshed relationship, having the possibility of it.
Okay, can we just the mother has actually attempted to apologise, has she not? If you look at the evaluation session, which is in the supplemental bundle, starting at 194, on page 198, the notes set out in various sort of paragraph sections. At 19, we see a few lines down, the mother saying, "You were just a child back then. In any case, I should have done more to encourage you." I think in context that means take the medication.
Yes.
And I'm sorry I didn't. I'm sorry, darling. I apologise. Now, you may say that's not that didn't use the, if I may say so, slightly stilted form of words that apparently been prescribed for her. And you may say it wasn't really sincere. The judge obviously had great doubts as to whether it was sincere. But just on the point about whether there's been an opportunity to make the apology and see whether it works, speaking for myself, this reads to me like the mother attempting to follow the script that had been given her, and it doesn't work. I think there's another passage to broadly the same effect, but even if that was the only one, I won't spend time reading it all through. So, just feeding into your submission that there should have been an attempt to give her the opportunity to make the apology, my understanding when I read this, I thought, oh, well, there's the mother apparently making the apology with all the qualifications that I know you will say are there, which I fully understand. But in terms of whether it's worth giving another go, it's been given a go already.
Well, my Lord, not in the terms that Dr. X provided for in evidence at the hearing in January, which I set out earlier in paragraph 31 of the judgment at page 97.
But that can be done as part of the plan and the way forward. I got your point on
Yes.
sequencing, Mr. Carey,
Yes.
But let us work on the basis what the mother said there was inadequate. A fuller apology could be built in. Whether it's accepted or not is another matter, but it could be.
But my Lord, yes, it could be built into the care planning, but in my submission, it is something that ought to have been considered before the court made a determination on long-term residence. And the sequence, as I say, just quickly moving on, in terms of this, the sequencing point, is that what the judge has done, which is set out at paragraph 46 of the judgment at page 101, is to consider best interests in the following way. First of all, to consider the feasibility of continuing covert medication wherever A is residing. Secondly, to whether the continuation of covert medication in any setting is in P's best interests, paragraph 46, page 101. And finally, if A were to be informed of the fact, should A be informed of the fact that she's been covertly medicated. That's the sequence of decision making that he's made. In my submission, the proper approach should have been consideration of whether HRT is in A's best interests.
Well, he said he did consider that, didn't he? And we keep going. Sorry. First he should have considered whether HRT is in A's, but then
how the medication can be administered.
Yeah.
The third is the allied work with the apology and another expert. The fourth is then to critically analyse whether A could be covertly medicated at home or in independent supported living placement.
Well, he did that. He did look at that issue, about whether covert medication was realistically or was workable in the community, and concluded really it wasn't.
In the community, he concluded that it was workable, but that there are risks that are present in covertly medicating A.
Did he?
Not in the community in the sense of independent living placement. Sorry, forgive me.
I thought even that. I seem to remember him being very sceptical about that.
Well, he concluded that it was feasible.
It was feasible to try, possibly, but it would mean care workers having to come and have an excuse to bring food, and the grounds for his scepticism seem to be pretty convincing to me. Anyway, I don't have to be convinced, just have to say they're reasonable.
Well, my Lord, exactly what's been happening for the last couple of years.
No, that's all the difference between supported living, which is the kind of community care you were focusing on, and in the care home, there's every difference in the world. I mean, her life in the care home is regimented. She doesn't produce her own food, and it's easy, as it's turned out, at any rate possible, for a prolonged period to give her covert medication. But the judge said it's completely different in supported living accommodation, supported independent living, and for reasons which seem obvious. Anyway, perhaps we're getting caught up on detail.
Yes.
The real point was you were going through all the points, that the things he should have considered in sequence, but so far they're all ones he did consider.
Well, my Lord, the way the judge considered it was to consider the feasibility of continuing covert medication, then went on to consider the continuation of whether covert medication in any setting is in P's best interest. Then finally, whether A should be informed that she's been covertly medicated. Now that is, you may say, well, Mr. Green, the sequence means nothing, but actually, in my respectful submission here, the sequence does make a difference if one considers beginning. At the beginning, is HRT in A's best interest? Yes, it is.
Right, can I ask you this? You start, so the starting point is HRT, which is a pill, or a patch, whichever way one chooses to take it. But that seems to be the key professional concern here, is that this person is not accepting taking a pill once a day. There are also very understandable concerns about the young person's life at a psychological and a social level because of the extraordinary way in which she's been brought up. But can I just understand, let's suppose A did not have the misfortune of having POI, and had other misfortunes such as epilepsy and so forth, but that we were not talking about PI, would we seriously be thinking about keeping her deprived of her liberty in a local authority resource because she was under-socialised?
Well, my lord, those obviously each case is fact specific.
Yes, but I mean let's just
But
examine.
Probably not, my lord.
No, I mean it would seem bound to say to be
Yes.
an extraordinary idea that one would take somebody into care just in order to make sure they had more experience of life and friends. By this stage, you'd be doing it when they were a child,
Yes.
if you needed to do it at all. So accepting that there is a very grey hinterland to the pill issue, that's really what this comes down to, is whether the court was bound to say that this person should remain deprived of her liberty in state care as opposed to home care, to make sure she took a pill once a day.
My lord, the case previously was far more stark in its...
Yes, and nobody is challenging at all,
Yes.
although there may be lessons to be learned about procedure, the need for A to go through puberty.
Yes.
But that's now 2 or 3 years ago. So now we're talking about just keeping somebody where they don't want to be, to make sure you can give them medication once a day that is highly desirable but not absolutely immediately essential.
Well, my lord, there are other factors, including plainly the enmeshed relationship, which
But
hasn't changed.
plenty of people have enmeshed relationships. Plenty of people have appalling relationships to live in. We're not going to be taking people into state care for that. So it doesn't it, Mr. Green, come down to the only justification in the end for the official solicitor advocating for a client to remain in a home of this sort is to make sure she keeps taking a pill without her knowledge.
Well, my lord, it's more than that, and I'm not suggesting that the court should have made a determination that it was in A's best interest to live in an independent living arrangement forever. What I'm saying is that when the court made a determination that it was in A's best interest to return to live with B, that should have had significant weight should have been placed on the enmeshed relationship. Significant weight should
The only importance of the enmeshed relationship is that it means she's not likely to take the pill. It all comes back to the pill, does it not?
Well, it's
The fact they have a weird relationship is not a reason for separating people.
Well, I'm not suggesting that separation should be long-term.
But you're saying
that's
it
not
should
the
be
official
indefinite.
position.
It should be indefinite, it seems to be the plan. These proceedings will go on indefinitely.
No, my lord, what I'm suggesting is that, as my first point was, in the fourth point of issues of magnetic importance, it is fundamental that A should be given the opportunity to take that medication voluntarily.
Well, effectively, the focus of your submissions, I appreciate not all of your submissions, is on effectively the prematurity point.
Yes.
On which we heard Mr. Gollop and Mr. Sorry, and which we certainly have understood. I'm looking at the time.
Yes.
But that is really what this is about. I mean, I think you are accepting that if the present impasse were present in, still continuing in, I take a figure out of the air, a couple of years' time, that would be unacceptable. But you're saying that other things should be done beforehand to see whether she can be persuaded to take the medication voluntarily.
Yes.
Well, that's anyway. I'm noticing the time, and that was quite rightly the first of your 6 points, earned in making a final determination. Several of the rest we explored as they went along. The ECHR one, the point about weight. The remaining 3, which you haven't yet developed, but I'm wondering whether you really need to, are that he conflated the decisions on residence and medication. That's really been implicit in the submissions you've just been making to us.
Yes.
that there was, it was difficult to reconcile a decision to let her go home in circumstances where you were critical, effectively, again, of the enmeshed relationship. And fourthly, inadequate consideration of the yes, effectively, the decision to cease, immediate decision to cease covert medication and inform the A that it has happened. Have you sufficiently developed those points in what you've said so far? I'm inclined to think you have, but
my lord, if I can just briefly
yes,
just outline those 3 points.
well, you have outlined them already.
Just if I could develop them extremely briefly.
Well, you were only going to be 3/4 of an hour when you were going to be dealing with the guidance point.
Of course. My lord, I will be.
Well, okay, you have to be very brief, yes?
Of course. My lord, in terms of the first point about reconciliation, the subcategory, there were 2 subcategories. The first one was meeting A's needs at home. And I think I adequately outlined that prior to the court making a final determination, it ought to have considered, in my respectful submission, and this is part of parcel of the unfortunate nature in which the written submissions were made and there was no dialogue, but there ought to have been proper consideration of A's needs and whether B was able to meet those needs at home, because the package of care that the local authority has advanced is community access 3 times a week, as I understand it. There is no delivery of care in B's.
Well, that's inherent in, yes, of course.
So there needs to be some consideration. In my respectful submission, there was no consideration of that. And the importance of that is that in the previous proceedings in 2017, before Her Honour Judge Moyer, the evidence from the consultant psychiatrist that there was a need for B to understand 3 things. First of all, appreciation of A's needs. Secondly, an understanding of her needs. And finally, compliance with any plan. And that's outlined in the judgment at page 165, paragraph 100. It was called the trifactor requirement, which Her Honour Judge Moyer then reconsidered at a review hearing in 2019, and reference to that, my lords and lady, is at page 167, paragraph 107. And the review hearing in June 2020, which commences at pages 172, concludes, Her Honour Judge Moyer concludes at that stage that the trifactor requirement hadn't been accomplished, or that B hadn't developed that understanding. And my particular reference to that is at paragraph 34 at page 179. In evidence at the hearing in January, Ms. S confirmed in oral evidence that her view was that that trifactor requirement hadn't been established.
The judge accepted that.
Yes. And so we have a finding that B is unable to meet A's needs. And there is a logical misstep in my respectful submission. If it's determined to be in A's best interest to return to reside with B, there must be some consideration of whether B is capable or indeed has changed.
But the judge was clear she wasn't.
Well, then,
but that doesn't mean that that it shouldn't happen. He's having to choose between situations, none of which would meet her needs in a perfect world.
yes.
So this point doesn't really go anywhere, does it?
Well, it's again a matter of weight.
Best interests is not best interests in some theoretical sense, but best interests among the available options.
Yes. And the available options in my respectful submission, when one considers all the reasonable circumstances as one is required to do under section 4.2, the weight tips in favour of A, at this stage, not returning to reside with B.
Yeah, well, I think we are just making the same points again, aren't you?
Well, these are tangents of the same point, my lord, yes.
Oh, all right, but
my lord and my lady, the final 2 points which I just briefly to cover is in relation to the decision to cease the covert medication. As has already been highlighted by my lady, no party was seeking to put forward or argue that the covert medication should cease. All parties agreed that it was in A's best interest to be medicated, number one, with the HRT, and number two, that it ought to happen for the time being, covertly, subject to further work being done to convince A to overtly
What does it matter that all parties agreed when it's perfectly apparent that B's agreement was built upon no reasonable foundation at all? She was putting forward a plan that the judge unhesitatingly rejected. So, I mean, agreement doesn't amount to much if one of the agreeers
Yes.
is doing it in that way.
Yes, my lord, I highlighted simply on the basis that no party was asking for a decision.
So is your real point then, so the judge wasn't entitled to decide that that was best?
My lord, I say at this stage it wasn't. For the
No,
same
I'm not.
reasons.
At the moment, we've gone beyond the at this stage. You've done your at this stage
Yes.
arguments. We're talking about now the assuming that he was entitled to make a here and now decision. Is it your submission that he wasn't entitled to reach the conclusion that he did about the cessation of HRT because no party had been actively advocating it?
But I say number one, yes, but that the foundation of that argument is because of the conflation between residence and covert medication. And that goes back to my second point that I made earlier, that if he adopted a different sequence, a different decision would have been made.
Could you just, I speak myself, I haven't quite got that right. What's the change in sequence that he ought to have?
That he ought to have first of all considered whether the HRT is in A's best interests.
Right, he decided it was.
Second, decide how to administer it.
Decided it couldn't be administered at home.
But it could have been administered covertly.
Not at home.
yeah,
Not at home, but in an independent setting.
Right.
It was
So he
possible,
took
feasible.
into account it couldn't be administered at home.
Yes, but in terms of an independent living scenario, his conclusion was that it was feasible, although there were apparent risks.
So he didn't think much of that as an idea. So what is the sequencing difference that is needed here in order to reach a different decision?
Well, my lord, then the position would have been that B would have provided for the apology and had further work done to convince A of overtly taking the medication, and then there would be a final consideration.
Yes, so it just speaks for a preference for a more cautious approach.
Well, an approach which, in my respectful submission, it would have been in A's best interests, having regard to all the reasonable circumstances.
But your case has got to be, having got to the point where the judge was entitled to make a decision if you're there, that the judge was obliged to take a more cautious approach. He had no choice, no reasonable choice.
Forgive me, my lord, it was...
He had no choice but to take a more cautious approach, because if he had a choice, he was entitled to make it.
Yes, my lord, he had a choice.
well then, if he had a choice, then you have no ground of appeal.
No, he had a choice.
You've got to say it was a choice which he could only reasonably have taken one way.
But
That's what we do on appeals,
Absolutely.
especially in a case like this.
Absolutely, but under a Section 4 determination as to what's in A's best interests, in my submission, he erred in making that determination because of not adopting, for instance, the least restrictive approach in respect of A, which would have been to allow her to overtly take the medication, or at least allow her the opportunity to overtly take.
Well, this is a new point, but surely the least restrictive approach in terms of her liberty is to allow her to go home. The least restrictive approach, the whole point about restrictive, is in favour of the solution that B wants. What goes in the opposite balance is the harm to her health.
And harm to her autonomy.
You don't have more autonomy in a home, in a care home, than you do at home, even if you have a very very unhealthily close relationship with your mother.
Well, a relationship, my lord, which has no boundaries between the two people.
I don't mean no boundaries, but
Well, my lord, those are Mr.
well, we're just playing with words here. Anyway, what is the error of the judge had a choice as to what choice to make, and you were before we intervened, you were about to identify what it was in law that he got wrong in making that choice. Speaking for myself, I've seen what you've already said in your skeleton and what you said in your oral submissions, and I see what the error is said to be.
My lord, yes, and it's set out there. I believe I've set out in my oral submissions as well as my skeleton argument the point about wishes and feelings.
Yes.
And we've explored that
we explored that when you were doing it first time round.
And finally, in respect of the balancing exercise, that was required in my submission in terms of the competing engaged articles of the European Convention.
Yeah.
Unless I can assist you any further.
Thank you very much indeed, Mr. Cream. Sorry, this point I haven't raised, my lord and my lady, and I'm not questioning. I'm just a little bit surprised to see the next person is Mr. Michael O'Brien. Wouldn't one expect the trust which is supporting the appellants to go next? I just want to understand the thinking. I'm not wanting to change the order the parties seem to have agreed on.
I think it was imposed on me by the others, as I recall.
You didn't like the idea, Mr. Michael O'Brien, of having to listen to 3 appellants before you even got on your feet. Was that it?
My lord, I didn't have any great concern either way, so I'm very happy for Mr. Joseph O'Brien to go next.
I'm sorry, I should have raised this to my lord and my lady.
Yeah.
Frankly, I don't want to disturb things unless you. Yeah, well, my lord, my lady, though I hadn't raised it with them, have the same view, and if it doesn't put you at
It doesn't. I can be relatively brief.
I think you can. Like Mr. Karim, a chunk of your written submissions are an area we have invited you not to deal with.
Well, the primary reason for the trust making submission was to address actually the issue of covert medication because of the consequences for the trust and wider clinical professionals. So we assume that was one of the reasons why the court, in the knowledge that we supported as opposed to actively had our own grounds of appeal, wanted us here.
I didn't know that Lord Justice Baker had positively said you should be here, but I'm sorry if you brought here under false pretenses.
From his grounds, from his permission.
Before we, as it were, leave the covert medication in principle issue, there is one point which doesn't trespass on medical matters, but is to do with the organisation of hearings of this kind, where there is as it were, a medically withheld fact of this kind. And one of the points that is made on behalf of B is that it creates a great difficulty where the proceedings are continuing in the long term, with one party being in ignorance of a significant element, central element in this case, and the issue of the appointment of a special advocate in a case of that sort, where the infringement that is being contemplated is of quite a degree of seriousness.
As it was here.
Yeah, as it was here. I just wondered, before you left the generalities of the matter, whether the trust, which has its own distinctive view of this type of case, had any observations to make about that.
Not in the sense of the ability of the Court of Protection as well. And I'm not sure that the Court of Protection does have the power to appoint a special advocate. I have to be very, very clear about whether that power actually does exist. I know it exists, I think, in civil courts now and in the family courts. But I'm not 100% sure whether, in fact, it does have that power in terms of its current statutory framework.
Is that something that, I don't point directly at you, but I wonder whether, as it's searched through the rules, both the COP rules and also the White Book but could we be held to that after this hearing?
You could, as I recall, and I hope I'm not giving too much away, when the guidance was issued by the Vice President following this case and following representations that had been made about what had happened in this case, my recollection, because I was actually on the subcommittee that was appointed, so I want to be a bit careful, but my recollection is that one of the reasons why there was nothing referred to in that guidance was because there wasn't a unanimous view as to whether the Court of Protection did have the power to appoint a special advocate. So I'm quite happy after the hearing to actually put together what may well be the statutory framework and perhaps canvass views amongst my colleagues at the bar here as to whether they do take the combined view.
Yes, that would be very helpful.
I think that would be very much appreciated.
Yes, but in terms of a closed hearing in this case, of course, the factors which influenced Her Honour Judge Moyer were very stark, which was that there was no confidence at all that B would comply with orders of the court. There were concerns about how you would know that the orders of the court were breached because there was issues about how she communicated with A, she communicated herself in a covert way with A, and there was a huge number of factors which influenced Judge Moyer in the way she dealt with this issue. And just to allay fears that do arise about what happened in this case, all the professionals in this case, the local authority, the trust and the official solicitor, at every one of these hearings and in advance of the hearings before Judge Moyer, asked ourselves the ultimate question whether this was the best way, the only way of actually achieving what everybody agreed was in A's best interests, which was covert medication at that point. And there is a perception, if I may say, that this was all done at times very slight-handed and we ran into it. It was not. We waited a considerable period of time, my lord, my lady, for trying to encourage A to take the medication before the application was made. And my lord, you asked the question whether, in fact, the reality here is that the covert medication is the real reason why B is separated from, A is separated from her mother B. It is. It is. I can't, at the moment, see any other reason, social care reason, which would have led to this. There was an MS relationship. It was extremely unhealthy. But the reason why the court made the decision was primarily to facilitate the medication to address the primary ovarian insufficiency.
A different question, if I may, which was to do with the fact that one of your professionals, Dr. X, became a central figure whose evidence was clearly highly respected by both the judges who considered this matter. Ms. Justice Poole makes the remark that it's undesirable that somebody like Dr. X, as it were, finds himself in the position that he did, where he's sent both the treating clinician and also giving expert evidence to the court. Could you just remind us? I think I've read it, but I can't remember now. How did that come about? Because more normally one would have expected somebody to come in, particularly where the official solicitor was involved.
I've been in this case 5 years, but there was a history before my involvement. So I came in it towards the early part of 2019. But my recollection is that it was felt by all the parties in the case then, as they were represented, that because Dr. X was a nationally recognised and an internationally recognised endocrinologist, and because of the issue at that stage about the reach of his influence, particularly in the NHS, that no other expert would have been accepted in terms of persuading A or B.
So it wasn't a missed opportunity, it was a balanced decision with this special feature in it.
That's my recollection of where we were at that stage, because that did feature in the first hearing before Her Honour Judge Moyer, because B, of course, decided that what she wanted to do was arrange a consultation with somebody unknown in York at the time, who she believed would not know the influence of Dr. X. But of course, he is, as I say, I mean, I think it's accepted by, and it was accepted by all the judges, Judge Moyer and Mr. Justice Poole, that he was a nationally recognised, internationally recognised endocrinologist. So people were asked, an NHS consultant, do you know Dr. X? People would have been saying yes. And I think that was the primary reason. I did read that at the time in the judgment with some interest, because I'm not sure Mr. Justice Poole was fully aware of that in fairness.
But what it means, I mean, that's the reality of this case, but what it means is that where people have been living with the case for a very long time, and you have an intractable situation of the kind that arises here, sometimes one never knows. An outside eye may see things that others don't.
Well, that was, in fairness, the purpose of Professor Z.
Yeah.
Professor Z's purpose was not to actually look at diagnosis again. There's no point in that. We're past that stage. Professor Z's purpose was to seek to persuade A of the benefits of continued maintenance medication. That was the primary purpose for her involvement. And that is a common feature of the case, that the optimum outcome here for A is that she takes the medication voluntarily, because the consequences of her not taking it voluntarily are significant. She may resist the involvement of social and medical carers, one of which, of course, is her epilepsy, which is well controlled. And one of the dangers, one of the fears is, of course, that may impact upon how she reacts to the continued epileptic medication that she has. And the second area of concern in relation to that as well is that it may well lead to a breakdown in the support network, which may well come through her mother, if her mother has to tell her that I have to apologise because it's me who got you wrong, and by the way, you were covertly medicated. So there are one of the troubles that the trust has, and it's listen very carefully to the exchanges about this, because the point that the judge made as well in his judgment was the ultimate outcome here is this is life, this is long-term covert medication for life, and the trust accepts that is an issue. What troubles us about the way this hearing proceeded, and this is very, very unfortunate, is, and I was corrected by Mr. Mike O'Brien actually, B concluded her evidence on the Thursday, and it was the social worker who was to give her evidence on the Friday. B didn't attend a court on the Friday, as I recall it, because she had fallen in Leeds City Centre, or she suffered an injury and been hospitalised on the. And she then arrived late on the Friday for the conclusion of the evidence of the social worker. And at that point, because it was late in the day, and because the judge faced the prospect of hearing 4 sets of submissions from all of us, that it was decided that it would be written submissions. But I have to be frank with you that none of us perceived, certainly on behalf of the local authority, the official solicitor, and myself, that covert medication, the stopping, the cessation of covert medication was on the agenda. And secondly, that this was anything but an argument about a trial at home.
And it follows from that none of you understood or experienced practitioners that the cessation of covert medication wasn't on the agenda. There simply wasn't, before the court, the exchange of views, of submissions on that issue.
Yes. Can I just take it one step back as well? My recollection is Dr. X was not really probed by anybody about medication, apart from going through what were the immediate consequences,
You mean the physical consequences?
physical consequences. And that's set out by the learned judge. And in fairness, Mr. Justice Poole did have those exchanges about the physical consequences. But to be honest, when I left the court building that day, my understanding was that this was all about a 12-week trial. And the focus was going to be on the consequences of the 12-week trial, not the cessation of medication, but how...
This would be a 12-week trial during which
the mother...
there would be no covert medication.
No, I think it was during which B would attempt to persuade her to take the covert medication.
Well, hang on, there wouldn't be covert.
Well, I think B would attempt to persuade her of the importance of taking the medication.
Yes, but what would be happening in the meantime?
My understanding is that the covert medication would continue.
Well, that was in the order that
Yes.
I thought it was in the order that was brought to our attention.
That was
this
in the
morning.
order, I think, that was
The draft
proposed
order
by
on behalf of
Mr.
the
Michael.
Yes,
Yes.
but that was only produced later.
That was produced at the time of submission.
Yes.
Yes, but so during the hearing, you were saying what your understanding was that everything was about at the moment that the hearing came to an end.
Yes.
So based therefore on how it had been conducted
Two
up to that
options.
point.
Two immediate options, which was staying in the placement where she currently is, and the trial.
Yes.
And the other option was the independent supported living option.
Well, can we come back to that? So that sounds to me like three options.
Two immediate options, and one option that would have required further evidence before the judge, which is the supported living placement.
So, but can I just explore the option that you understood was being advocated for by B?
Yes.
Which is a 12-week trial, the main object of which would be to persuade her in the home environment of the benefits of taking maintenance HRT voluntarily.
Yes.
Well, may I just ask, had any position been formulated by B as to whether covert medication would be attempted to be continued during that period? Because 12 weeks is 3 months at home.
Yes. Can I just say, Lord, you are, and I refer to this in my skeleton, that you're helped by the judge actually setting out what the various positions of the parties would be, and it's in the core bundle at page 100, paragraph 40.
So there, you've got the covert medication
Yeah.
there.
Let me just see.
Sorry, could you give the paragraph number again?
It's page 100, my Lord, the core bundle, paragraph 40, and it's under the heading the parties' positions.
Yes, I see. So, well, that's fine. So
Yeah.
there would have been obvious difficulties, but that was the proposal.
Yeah. And I can't get away from the fact that the judge, when he analysed the proposal that was being put forward by being for covert medication, thought it just would not work. But that is what B's position was. So Mr. Cream's already, I think, referred you to paragraph 53 of the judgment, page 103.
Yes.
He said the proposals for covertly medicating her own were so flawless to suggest that she has no real intent for them to be effective. And I have to say again, that was my appreciation of the evidence at the end of the hearing. It was a flawed plan.
Yes. Can I But who would that plan? With which witnesses had the practicalities of that been explored?
I think both Dr. X, briefly, think, unquestionably with the social worker, and also with B herself in her evidence. And the plan vacillated between potentially some people coming in
Yes.
and the other option of taking A up to her grandmother's, where two of A's carers would be there. And the
Yes, no, I
proceeded along. Well, what questions will they ask about why are her carers at the grandmother's?
yes.
And it was that.
Yes, no, well, I remember that passage
Yeah.
of the judgment. Can I, though, just exploring the extent to which the evidence might have been different if you had appreciated that the stopping of covert medication altogether and an explanation that it had been going on,
Yes.
what different evidence would have been adduced?
I've given that some thought because, and I've given it some thought because the ultimate question for the court is what do you want us to do, or what do the appellants want the court to do in terms of should this go before another judge? And I have to say, I find that the answer to that quite a difficult one. But I rather suspect it would have been proved greater with Dr. X.
But in a sense, what he's not in a better position than that. He's obviously extraordinarily eminent to talk about the consequences of discontinuing the medication, and he gave evidence, all of which the judge accepted about that.
Yes.
He's not particularly well placed to give evidence about the family dynamics or the choices that A would have made, or A's reactions,
Yes.
if all this had been said to her. He'd only ever met her once, as I understand.
He had very limited interaction with her.
So, I mean, the court is bound to be concerned about a situation in which an important area wasn't properly explored in the evidence.
Yes.
But at the moment, I can't see what witness would have, on this point, been in a position to say anything that would likely to have affected the judge's assessment of all this.
It may well have been the social worker who could have given better evidence, who did know A better than any other professional.
Even then, it would be largely speculative what her reaction would be. Nobody can know what her reaction would be.
It would be, I don't dispute that. But perhaps the biggest concern is the fact that it wasn't out in argument.
Yes, well, I do see that. So,
because one of the I don't want to go on sounding as though I'm taking a view about lockdown. One of the dangers of lockdown is we have got used, I suspect, to not having those very, very important exchanges between experienced judges, but also experienced practitioners.
yes.
About the consequences of what goes on at the, if I can use the phrase, the coalface, in terms of commissioning decisions, who is responsible. For example, that this would not fall on the trust. The trust's responsibility is essentially consultant services led, but there would be the question of whether the GP would be involved. There would be the question of whether there would be another potential learning disability service who might be involved, what their views are. And the arguments would have developed then around about what were the options, the realistic options. It may not, I can't say it would have ultimately led, in a case as complex as this, where the judge says, this is the most difficult decision to a change.
And given how very difficult this decision was for all, exploration and what becomes discussion, does it not, between experienced practitioners in the court?
It does. And it has a value. It has a value. And in a case such as this, where you are looking at not just the functioning of the Mental Capacity Act, but also its interface with the local authority's obligations under the Care Act 2014, that those exchanges, in my respectful submission, were an essential part of the jigsaw of determining what the outcome could be for A in this case.
But no one said to the judge, look, this isn't a case in which written submissions alone are going to be adequate. I'm not criticising anyone, I'm just trying to get...
I think the feeling was that if we'd got the time, we would have had oral submissions. But at the time we were at, and you can't blame the judge for this, and I don't, he's a very experienced judge, and a very respected judge in terms of his work in the court of protection. But we did look for a date when we thought that we would not use that Friday. I think it was a Friday. You talked earlier, my lord, about the ageing process. I'm afraid it's affected me much more than most. When I can't remember days 2 or 3 months ago, but I think it was a Friday where we were at, and we could not fix a day within the next 2 or 3 weeks, as I recall, where we would all be available for a day to finish social workers' evidence and submissions. And that's where the judge's hands were tied. But the problem I have beyond that is, the judge then got the submissions in, and it was clear from all these submissions that the real position of B was a trial, as the judge points out. And none of us have really addressed an immediate return, immediate cessation, and effectively concluding the proceedings with a final plan.
You say the real position of B was a trial?
A trial of
Yes,
B was a trial. It was 12-week trial.
taking a worldly wise view of this, that no judge would be likely to view that as being the boundaries of the situation, because that's not what B was after at all. B was after a return home.
She was, my lord, very, very clear in the written submissions put to the court that this was, the proposal was a trial of 12 weeks.
I understand that, but what your submission appears to call for is to credit what B says in that instance, but not to credit anything else she ever says.
Well, I think you have to see that within the context of the litigation process we were in, which is we were making submissions on what we thought were the respective positions of each.
But essentially the argument that we're considering at the moment is that the trial process was unfair. That's the gist of grounds 1 and 2.
Of course it is, yeah.
Yes, and
my argument is we won't.
And the authorities about that are perfectly clear that people should not be able to be wrong-footed.
Yeah.
People should not be able to, judges should not go off-piste, to use familiar expression.
Yes.
So the question for us really is to whether the outcome that the judge came to was beyond contemplation in the overall circumstance of the case, in terms of being a potential outcome.
Well, in my respectful submission, it was.
Right, that's the submission.
That is my submission. I rely very much on what the judge says at paragraph 40 to set out the various positions onwards of the parties. Maybe we were naive, my lord, to not address that. I'm not sure we were actually, but that may well be the view that you take, that we were naive, that we should have been more open to cessation of covert medication and also a return home.
I mean, this isn't ordinary inter-parties litigation. Maybe the test isn't quite the same. I.e., was either party misled and therefore prejudiced because of their misunderstanding of what the other side's case was or the basis on which the judge was thinking.
Yes.
It should be, and there may not be much difference, but I think there is some, simply did this lead to the judge not considering or having the opportunity to consider questions which were relevant to A's best interests?
Yes.
Because if it didn't, it doesn't really matter if the professionals feel aggrieved or we didn't have the opportunity to put this argument or that argument. So you've, I think, got to say, and I think you do say, that because of the course that was taken, the judge actually was deprived of of an area of, you put the emphasis more on discussion than evidence, that would actually, or might actually have led to him making a different view about A's best interest.
I mean, one of the areas and grounds that the local authority relies on as well is the focus on deprivation of liberty here. That currently, B is deprived of her liberty as though she would not be deprived of her liberty at home. And there would have unquestionably been an exchange, no doubt on behalf of the official solicitor and the local authority, and possibly the trust as well. Because we have respectfully looked at this and concluded that there would be a deprivation of liberty at home, more likely than not,
Well,
in circumstances which would be, in fact, extraordinary for somebody, where you'd be saying, well, we are returning them to a home where there may not be the access to medical services that she does require.
well, hang on, that's not deprivation of liberty. That may be.
It's not deprivation, but it would go to the consideration of whether you should authorise the deprivation of liberty in those circumstances.
But hang on. I was rather dismissive, I hope not rudely so, to Mr. Karim when he suggested that going home could not be regarded as deprivation of liberty in the same sense as being detained in a care home, even if there was an strong element of psychological dominance, lack of autonomy at home. It's still not deprivation of liberty in anything like the same sense.
Well,
Are you saying it is?
My submission, it would be, yes. You'd have the ingredients of deprivation of liberty. If the subjective test is met, the objective test is met, the arrangements are imputable to the state. But whereas the deprivation of liberty, my lord, at the current placement, is there to promote her best interests, promote her personal autonomy, promote her long-term health needs. That's in contrast to what would be occurring at home, where the judge could not be satisfied that B would in fact access the services when she needed them, that there'd be the enmeshed relationship, that there would not be the promotion of her personal autonomy. All those matters were accepted. They are in there. The judge recognised all those factors. But one of the exchanges would have been, is A going to be deprived of her liberty at home, and should the court authorise it as being necessary proportionate in her best interests?
Well, I see the time. Speak for myself, I think we're on the most difficult part of the case. And I'm not going to stop you answering more questions from us.
Well, I've essentially come to my... I'm going to adopt what's in the submissions of the other parts, but those are the points that I wanted to highlight, in particular, that the opportunity, the lost opportunity to have those proper exchanges between experienced practitioners and an experienced judge nonetheless.
One thing that would just be helpful is if over lunch,
Yes.
I think you have more or less told us and come to an agreed position, but it hasn't stuck with me exactly what the sequence of events was in terms of the hearing.
Yeah, I think it's as Mr. Michael.
But I think I didn't make a proper note of it. So if you could just either give 2 sentences on a piece of paper, just, or dictate it when we get back.
I'm glad I was taken out of terms. It means
No, well, I think you would. Yes. Yes, well, that's what I was going to say. Yes, I mean, although you said you finished, we may not have finished with you. So we'll give you a locus penitentiae to think of any more you want to say. But we're not. I think you're right on the what I might call the substantive points in the case.
Yes.
About the judge's reasoning and so forth. I think you have effectively adopted that in your skeleton argument, and you're not going to say any more.
Repetition doesn't help, and there's no profit to the court in me just
no,
repeating
but
speech.
don't assume that Mr. Mike O'Brien, that you'll be on your feet absolutely straight away. There may be a little bit more. But I think I haven't worked out how this all works with the timings. I think effectively we're up to speed. You will have, I think, ample time to meet the points you've got to meet this afternoon. I'm not even sure we'll need to go on to 5 o'clock, but it's there if we need to. Very well. 2 o'clock.
Court rise, if able.